Friends, we welcome you to the Legal Breeze. Today we will be talking about certain important constitutional amendments relating to the reservation of OBCs in India is concerned. Please remember, the term OBC has not been defined in the Constitution. There are many terms used in many occasions for the different purposes. For example, reservation relating to education, reservation relating to employment, and other aspects is concerned. Say example, under Part 3, certain expressions are being used. Under Part 16, certain expressions are being used. But by virtue of 102nd Amendment and 105th Amendment of the Constitution, the things have been to a greater extent, by and large, it has been rationalized. So we'll be discussing about the importance of 102nd Amendment and 105th Amendment. Particularly, we would like to discuss what is the reasons for the 105th Amendment, why it has come, what is its significance in the center-state relationship. All these things will be discussed in this particular video is concerned. Please remember, we have already discussed about OBC reservation, the origin of the reservation system in India. We have also adequately focused on the Maratha reservation case. In fact, Maratha reservation case is one of the important factor for the 105th Amendment to the Indian Constitution is concerned. We have already told in one of our videos that during the British India itself, the OBCs have got, in fact, greater benefits prior to the commencement of the Constitution. For example, the OBCs have been given reservations, representation in the form of reservation in the lower house of Madras Presidency Legislative Assembly is concerned. But unfortunately, it has been curtailed in the Constitution at the time of commencement of the Constitution. That means the Constitution itself has done certain injustice to the OBCs. The only provision relating to OBCs happened to be under Article 340. That's the only provision. In fact, Part 16 deals with, it title says, certain special provisions relating to certain classes. What is this certain classes? It talks about SCs, STs, Anglo-Indian communities, and only in one occasion it talks about other backward classes. So that is how we should remember this. A number of provisions have been dealt, are prescribed, are devoted for the welfare of SCs and STs and Anglo-Indians. We do not say that they shall not entitle. Certainly, they have to be given necessarily certain additional safeguards or special safeguards. But why these OBCs have been ignored? That itself is a billion-dollar question. That the constitutional framers, at least the original constitution, does not contemplate or does not provide any such benefits to the OBCs. That's a very important factor that all of us should remember. Only by virtue of First Amendment, we are introducing a term called socially and educationally backward classes, SC, BC. But this term has been defined now by virtue of 102nd Amendment read with 105th Amendment under Article 366, Class 26, Subclass C. This is, everybody should remember, the term SCBC, that is socially and educationally backward classes, have been defined under Article 366, Class 26, Subclass C. Please remember this. Now, we need to go back quickly to 102nd Amendment. If you remember Article 338, it says there shall be a National Commission. Article 338 title itself, National Commission for SCs. Whereas Article 340 simply says appointment of a commission. There is a difference between a commission and the commission. Article 338 contemplates the commission. That means there shall be a commission forever. Okay, perpetuity. Whereas Article 340 contemplates only a commission. That means ad hoc. So the President can constitute a commission for what? For inquiring or investigating into the conditions of backward classes. Okay, that's the difference. So it is ad hoc in nature, Article 340, whereas 338 is permanent. So based on Article 338, 102nd Amendment includes or inserts a new provision in the similar fashion or the similar model for the development of OBCs by virtue of or by inserting a provision called Article 338B. That's not a problem. But the problem has come. You have verbatically copied Article 338. Only difference is Article 338 talks about the welfare of SCs. Okay, the commission mandate is to promote the welfare of the SCs under Article 338. Whereas the commission mandate is to improve the welfare of OBCs under Article 338B. We have copied Article 342 verbatically for the OBCs by virtue of provisions contained in 342A through the 102nd Amendment. This is the problem. Because SCs and STs, only one list will be there, and that list will be applicable for both center and the states. Till 77th Amendment, there is no reservation for OBCs at the center. It was prevailing only in the states. Some states calls it BC, some states calls it some other way. But anyhow, SCs and STs only one list, both for the center and the state. But this practice has been verbatically adopted by 342A that has resulted into certain chaos. There is a case called Shivashankar Raman versus Union of India, and this case has also been clubbed along with Maratha reservation case. And in this case, Supreme Court, there is a 5-judge bench, constitutional bench, which has given a ruling by 3:2 majority that 3 judges have held there shall be only one list prepared by the central government for all the purposes relating to reservation for OBCs, and that list has to be prepared by the central government in consultation with the National Commission as well as with the state government. All these things, that's it. The state government's powers have been totally curtailed by this judgment. Of course, there is a dissenting judgment led by Abdul Nazir and one more judge. They said no, state government can have a separate list. The dual list is feasible because prior to the amendment, prior to 1992 itself, OBC states have a separate list pertaining to OBCs for reservation in the state government jobs. From 1992 onwards, a separate list was maintained by the central government for the purposes of reservation in the central government and related offices. State governments are also maintaining their own list for the purpose of maintaining or providing reservations in the state governments in their respective sectors. That's it. But this position has been altered by the aforestated case laws. It is because of that particular reason 105th Amendment was necessitated. The bill number is 127th Constitutional Amendment Bill, so please remember that. But the Amendment Act is 105th Constitutional Amendment Act. This all of us should remember. Now, what is the difference between 102nd Amendment and 105th Amendment? 105th Amendment makes 3 changes. 1, it inserts a proviso in Article 338B. It makes certain amendments in 342A. It also makes certain amendments under Article 366 26C. These are the few differences. What is the net result? It makes it very clear by way of an explanation that the central list is applicable for the central government. That means state list is applicable for the state governments. So the dual list is permitted. Power of the state governments to maintain separate OBC list for the purpose of providing reservations in the state government and related undertakings is restored. This has been made explicit. This is very important. The term SCBC has also been defined under 366 clause 26C. There is another important issue. I think this is also related with this. Certain political parties have taken an initiative, particularly from Bihar. They have taken an initiative. They have met even the Honorable Prime Minister to press for what is that? Caste census. As of now, we are calculating or we are taking the caste in the census only for SCs and STs. But till 1931, OBC's caste was also taken into account when we are taking the census. But that practices has been stopped for whatsoever reason, which I don't want to go into for the time being. Now the time has come, because always Supreme Court asks you on what basis you wanted to give this benefit to the OBCs reservations. They wanted to know who has attained the criminal layer status under OBCs. People are also demanding subcategories within OBCs. So if you wanted to achieve all these things, all these objectives, certainly caste-based census becomes absolutely necessary. Without having a data, we can't do that. But please remember one fact. Whenever we speak reservation for the backward classes, whether it is for OBCs or SCs or STs, there is a stiff resistance. Including Supreme Court asks you on what basis you are giving 50% ceiling, you are asking census, all these things, statistics, all these things. Whereas when we have provided 10% reservation for EWS, it is believed that it is EWS means it is not cutting across the caste. It is only for upper caste. The upper caste constitutes only 3% of population, something like that. But for them, you wanted to provide 10% of reservation. It is huge, improportionate. Whereas it is believed that at least 50 to 52% of Indian populations are belonging from OBC. But what is the percentage of reservation given to them? Is it proportionate? In order to find answers for all these things, experts are opining that the caste-based census becomes absolutely necessary. We hope good sense prevail sooner rather than later. But in India, we need equitable solution, equitable distribution of resources. Distributive justice is absolutely necessary. For that, one should not get emotion based on caste. We all should feel the fraternity. That time should come sooner rather than later. Jai Hind. God bless you all.
Stop button.